So we had quite a few people say, I want in, I want to watch this. Um, and I posted the link at the last minute. And then I started playing around with this stupid Seanna Smallwood at iCloud. I couldn't get it off, but I actually remember putting that on here earlier today, and now I can't remember how to get it off. So anyway, I'll just go ahead and start this meeting. I'm doing a just kind of a quick glimpse of the issues with the NAR lawsuit. And I guess I'll just start off by saying, and if people come in, forgive me, because I'll have to I'll get a doorbell and then I'll stop what I'm talking about to let them in. So basically, just to give you a little background on me, I have been in the mortgage and real estate business for 35 years. I got in it in 1988. I was still in high school. And I was working as a part-time telemarketer at a mom and pop mortgage company in Waldorf, Maryland in 1988. And I was that annoying person that would call your house at dinner time. This was before all of the regulations and do not call, and ask if you wanted to refinance out of your 16% interest rate into your 12. And people were ecstatic. It was crazy that now the interest rates are 7 to 8%, even at 6.5% after the 3% and 2.5%. A couple of years, everyone's complaining, and it was literally double the interest rate when I got into this business. So I wanted to first put it out there that when I address these things, I know a lot about what I'm talking about. I've been a real estate agent since 2001. I no longer practice real estate. I just send referrals. I am a full-time mortgage broker with Edge Home Finance, NMLS 1252825. And I have a team, and we cover between Edge licensing and my team, we cover the United States, 48 of the United States. So just jumping right in here, because I'm recording this for anybody that couldn't make it today. What I wanted to do was just talk about a couple of the things that seem to be an issue, right? So I haven't fully read all of the case files or public records on the case, but I can tell you from experience, I already know what the problem was from the beginning. And so I was kind of watching it like, this is kind of strange to me, because since 2001, I have been using a specific listing presentation that I developed throughout my real estate career. This was before I started even originating loans again. And how I established this presentation was I would go on a listing presentation as a rookie. And then if I didn't get the listing, or I did get the listing, I would come back to my car, open up my notebook, and write down all of their objections. And then when I'm like a lifelong scholar. I keep changing my degree major, so I'm still in school. I just finally switched it to communications, and I'm going to move on at 50 years old. So at that point, I realized that the majority of the objections for the real estate commission was that, sometimes the seller, wouldn't want to pay the full 5%, especially, or 6%, or let alone 7%, especially if I was competing with an agent that, was offering 4.5%, right? So it became a struggle right at the time in the hot real estate market, 2003, 4, 5, 6, before the crash, that while everybody else was cutting their real estate commission, I was actually increasing it. I was charging 7% and cooperating with the buyer's agent or sub agent at the time, 4%, creating a competitive advantage in the MLS for in the marketplace for the seller. Because then the local agents would be kind of, spread like wildfire. And the agents that had buyers were literally looking for my listings because they got paid more. So in addition to that, at the end of my presentation, I would do the entire all about me. I would, from the knock at the door to the very last signature on the listing agreement, I maintained complete control over the appointment. And how I did that was I printed up a full-blown Microsoft Word presentation and sent them to FedEx, Kinko's, or Staples. And I think I'm getting a Zoom notification. I don't know. I can't tell. But I maintained control over the appointment the entire time because I was able to use all of the yeses and nos, and I kept track of all of the notes after every listing appointment. I didn't technically keep track of the agent that I was competing with. I would just keep track of why I thought I might not get the listing, right? Or why I thought so-and-so did get the listing, or why I thought I did get the listing. So I would keep these notes, and I created a listing presentation. And at the end of the presentation, instead of, and I'm a rookie at the time, right? When I started doing all of these, notes. So I have the legislation and the regulations and, the price fixing, all of the rules about real estate commission, it already fresh in my mind. And, in my mind, I was like nervous about breaking those rules, because when you're a rookie and you just learn all the real estate laws in the state, the last thing you want to do is break a rule. So what I did was I realized that the price fixing rule, which is the basis of the majority of this lawsuit, the price fixing rule was something I circumvented in my listing presentation from the start. And I had 3 options always. Ever since I was a brand new agent, I gave the seller 3 options on the real estate commission. Now, I didn't build this because of the price fixing, but I put that in there because it's a sales strategy to give a seller, a diehard 6, and to sit in that awkward moment at the kitchen table where they're looking at you like, I'm not 6, I'm not paying 5 when Susie said 4.5, that awkward moment. I decided that it would be excellent sales psychology to put 3 options, plan A, plan B, or plan C in my listing presentation. And it's always been in there, okay? So because it's always been in there, I really didn't have the problem. Now, there is a change. You cannot say, now my listing presentation that I've taught hundreds and hundreds of Century 21 agents, I used to have a Fiverr gig back when, after the market crashed, where I would brand my listing presentation to people on Fiverr and sell it to them and add their bio, their picture, their market, all of their stuff to my listing presentation. And then I would teach them the dialogue of the presentation. Some got it, some didn't. It's pretty intense. The presentation is intense. So, but it wins the listing, right? There is no more questions at the end of your presentation. If you can control your appointment from start to finish, the seller will have no more questions at the end of the presentation, no more objections. You've overcome all of their objections and even overcame objections before the seller even knew they had them. So it's really psychological, like psychology focused marketing and sales dialogue. So having said that, there are a few things that have changed over the years. One of the things that is in the original presentation is a frequently asked question, like list, a facts list. And there's like, I don't know, 10 or 15 questions on there. And I'll show it to you in a minute. It was my old Exit Realty. Now I started it at Central 21 and I went over to Exit. And so it has all the Exit branding. But one of the things that I said in that dialogue in the frequently asked questions was, why is, addressing the 7%? It's not, I would not take 3.5. I would only take 3 and I would co-op 4, whether it was to the sub agent at the time or to the buyer's agent. Okay. Now, in doing that, one of the dialogue in the presentation was that if if you're a real estate agent and it's a Saturday morning and you have a buyer coming in, you get them pre-approved, you're all ready to go, you have them set up, they showed you set them up on the search, you have 8 properties to show them on a Saturday. Through discussion and printing out full listings, you narrow it down to 5. Of the 5 listings, this is something you cannot say anymore as a result of the lawsuit. Of the 5 listings, there are, and it's really, well, I'll tell you what the dialogue is first. Of the 5 listings, 2 of them are paying 3%. 1 of them is paying 2.5%, and 1 of them's paying 3.5%, and the other one is 2%. So they're all spread out on buyer agent commissions. Now, here's what I am confused about with the lawsuit. Okay. So the buyer agent agreement, the exclusive buyer agency agreement that the agent has the buyer sign before showing them properties, or especially at the very last minute while they're writing the contract on the very first offer that they make. Okay. The buyer's agency agreement spells out in the agreement. Now, I hope all of the NAR attorneys watch this video, and I'll send it to the former president and CEO, Bob, because I'm friends with him on LinkedIn. But one of the things that blows my mind about this lawsuit is it doesn't make any sense how the lawyers did not see this. Okay, the lawyers for NAR, because the exclusive buyer agency agreement literally says in the very first page at the bottom, well, I guess it's different for each state, but in the very first page at the bottom, it says, in the event that the seller's listing or the listing in the MLS is not cooperating with buyer agency or not paying a buyer's agent, then the broker and buyer agree that the buyer will compensate the buyer's broker, the buyer's agent's broker, X%. Now, when I was selling real estate, it would say 3%. So when I'm in the conference room on that Saturday morning, getting ready to show 5 properties, and I'm doing my buyer presentation with that buyer, I go over the exclusive right, not the exclusive right, the exclusive buyer agency agreement with the buyer. And I explain that in this paragraph, it says, if I show you and you want to buy any of the listings that have the 2.5%, it's my job. I wouldn't be doing anything fair if I didn't tell you that the agreement in here, and what I have worked out with my broker at ABC Realty, is that if it's shorted by 0.5%, like these 2.5% listings, or buyer agency commission listing in the MLS, then you would have to pay me the difference, my broker, not me. Okay. Now, if that is the case, I'm already explaining to the buyer that through this buyer agreement that you have to pay the difference. Now, I'll show them all to you, right? I'm not going to not show them to you. But why is it that this lawsuit made it a conflict for the broker to explain to the customer, and if they sign the agreement, the client, under fiduciary duty, that their fee will be X if the seller won't pay it, any portion of it. So it blows my mind that the lawyers didn't address that. If they did, they didn't do it good enough, because from anybody's perspective, let's just say you are going to retain a lawyer. Okay. The lawyer says my fee is $500 an hour, and to retain me, it is $1,000, because I'm at least going to be 2 hours on your case. Okay. Now, if the buyer says, okay, that's cool, nobody is going to, if it goes down through the process on the case, and either through litigation or mediation, the result is that the other party, the defendant or the other party to the suit, had to reimburse or pay for the attorney fees, then why would it be okay for the seller, or not the seller, but the other party, to have a say in what those attorney fees are? It makes no sense how the National Association of Realtors was beat up over this. It just makes zero sense whatsoever. So my next point is, back in 2003, now this is in the state of Maryland, at least in the Southern Maryland Association of Realtors local board. But then after this case and some other cases that came with it or followed suit behind it, it seemed to have spread across Maryland. Now, Maryland, every state's different. Maryland has dual agency. Florida does not. Okay. You could be a transaction broker, but you can't have dual agency. All right. So in 2003, a local broker, and I'm not going to say any names, had a very successful mom pop, locally owned, no big franchise or anything like that, real estate brokerage. And this particular person, our agent and broker, she was producing broker, she had it in, she had a listing, and let's just say it was 6%, right? She took the listing at 6%, 6% listing, or maybe 5%, whatever, 6%. Let's just say it was 6%. And in the MLS at the time, we would systematically put 3% in the sub agency, 3% in the buyer agency. The problem with this one is that the listing agent decided to put on a 6% listing a 2.5% sub agent and a 2.5% buyer agent, taking 3.5% for her side. Okay. Now the problem with that is when they got to the closing table, and back then pre-COVID, everybody, buyers and sellers, attended closing at the same time, with both agents awkwardly staring at each other. So weird, but that's what it was, and that's what we did. So on the closing CD, back then it was called the HUD. On the closing CD, the listing commission that was charged to the seller was shown to all parties sitting at the table. Everybody got the same copy of the HUD one or the CD, okay? And the other agent, who did not have a buyer agency agreement, was cooperating for the seller, okay? She was a sub agent. That agent said, why is the listing commission and the sub agent commission split different? And it became a problem. At that time, that is when that broker, the buyer's, or I guess I should say, the sub agent's broker, who represents the seller as a sub agent, they are not even representing the buyer, okay? A sub agent for the seller represents the seller with the listing agent and listing broker. So both brokers represent the seller in the sub agency situation. So what happened was, to the best of my memory, was that the sub agent's broker went after the listing broker for the difference of the other 5.5%. Now, because the copy of the listing agreement was not available, it's not to be given to the buyer's agent. That is the listing broker's document. It doesn't need to be, it should never be uploaded in the listing documents. Some agents do that, but it's a complete error. They should not share their listing agreement with the MLS in docs, okay? So because the broker, the sub agent broker was in essence, and this has never come up before, okay? So it's weird for them to, I don't know, 20, 30, 50 years, 100 years later, they're finally realizing that this is a problem. The broker requested a copy of the listing agreement from the other broker since they both represent the seller in this transaction. And it became evident after litigation through, and mediation through the whole conflict resolution at the local board, they provided a copy of the listing agreement. And it said 3 and 3 evenly. So she had to compensate the sub agent broker the other 5%. She won. Okay. Now, what happened was after that, there was another lawsuit that came right after that, like not even a year, where this is gonna be an eye opener for everybody. So, and this again is in Maryland. So, but I'm sure it translates across the country because NAR decided to change the MLS settings and rules and guidelines and regulations against pocket listings and all of this. And everybody widespread started putting 0 in sub-agency comp, okay, in the MLS. So what happened on case 2 is they were at the closing table, and this is a situation where every buyer side agent is trained to be the bulldog for the buyer. It could be their sister, it could be their best friend, it could be their brother, it could be former clients, referrals, whatever. They are trained to be bulldog for the buyer, and then the listing agent is trained to be bulldog for the seller, right? That's their job. They believe in their fiduciary duty. That's what's going on here. Without any thought over whether or not they had a buyer agreement signed, which would designate who they represent. And especially after the whole sub-agent for the seller started saying 0, right? Without any thought, the seller had some receipts for some expenses that the buyer or the seller thought that the buyer should reimburse the seller for, because I don't even know why, but that's what happened, right? So now they're at the closing table all together, pre-COVID, everyone's at the same table looking at the same documents, and the seller and listing agent started arguing with the buyer and buyer's agent, whether I'm just calling them a buyer's agent without knowing whether or not they have a buyer agreement. I'm just referring to them as the buy side, okay? So the buyer's agent and the buyer, they're arguing. And as a result, I don't even know what happened with if it even closed, I can't even remember, but I can tell you what happened after as a result of the lawsuit. So obviously the buyer broker and the listing broker had a dispute over these expenses. But what happened was, because the agent sitting beside the buyer was, they did not have an exclusive buyer representation agreement signed in the litigation throughout the process of mediation litigation through the local board. It came up, do you have a signed buyer agreement with this buyer? When the agent said no, she suddenly represents the seller. It's a sub-agency situation, okay? Now we have a problem because the agent sitting to the left of the buyer at the closing table didn't even represent the buyer. They shouldn't have been arguing about the receipts at all. It shouldn't have been, they should not have been arguing with their client, the sub agent for the seller, and the listing broker who hired them to help her sell this property and represent the seller. Really deep crack there. I mean, it got really crazy. So after that, those two lawsuits, it went widespread. Sub agency for the seller is 0. Buyer agency comp 3 or 2.5, whatever it was. And again, if the listing broker and listing agent took a 6% listing and only cooperated in the MLS at 2.5, there was no recourse. You know your comp up front. You know what the listing broker and seller have agreed to pay the buyer's agent up front. So there is no more disputes. When you see the listing broker getting paid on the HUD-1, that's the problem that was resolved in the first 2 lawsuits. Lots of problems, right? So now, fast forward 25 years, whatever it is, we're looking at a huge class action lawsuit asking the National Association of Realtors, all the local boards, and all of the brokers to revert back to the way we were doing things before, and somehow made it illegal for the, or not ethical, or a breaking of the fiduciary duty to negotiate their own commission. It just was, it's wacky. So in this class or Zoom or meeting, I wanted to just touch bases on the history on how the sub-agent for the seller became a 0. And I'm sure my local board in Southern Maryland was not the only, association that got hit with all of those suits. But the confusion and the problem starts with, well, do those lawsuits need to be reversed? You can't have it both ways. It blows my mind. So the next thing that I want to talk about is how to present your listing presentation and how to help, if you're a loan officer, how to help your agent with the dialogue to present their listing presentation to mitigate all of the issues with the compensation, how to advise, how to sell, and I just went over what's different today. The other issue on that lawsuit is, I have a chat thing. Okay. The other issue on that lawsuit that I should bring up is when we're talking about, suggesting or having a conversation with your buyer about what they're going to be paid and how they're going to be paid. How is the buyer going to afford it? They kind of created a situation where, the people filing the claim or the suit itself has caused the industry to revert back to the original problem where the agent sitting to the left of the buyer in the representation or in the situation needs to clarify up front whether or not they work for them or work for the seller, which has always been the rule. I know the Maryland Association of Realtors, the National Association of Realtors, and the local Association of Realtors has a rule of the agency disclosure. That agency disclosure needs to be signed before or upon the first meeting. That agency disclosure, if they were having the proper, this all goes back down to broker training, right? Real estate broker training, local board training. Agents need to be accountable for knowing their job, right? So that document, it's understanding agency and who real estate agents represent. On the front of the document, it says, if you're a listing agent, if you're a buyer's agent, if you're a dual agent, if you're a sub agent. On the flip side, on the back side of the document, it says, The buyer agrees that their agent, Seanna Smallwood at ABC Realty, represents, and there's a checkbox, the buyer, the seller, or, sub-agency for the seller, or a dual agent designated by the broker. That's allowed in Maryland. There's some states where it's allowed. There's some states it's not. Florida, it's not allowed. But that document, it was a required document. Required. Like I managed Realty World, and I had a compliance checklist and I had teams, processing, transaction coordinators. I had a required checklist, and that agency disclosure must be in the file or nobody's getting paid. In fact, I'm sending the file back to you, agent, and I'm telling you to go get this signed because you're late on it anyway, blah, blah, blah. Good compliance checklist in Dotloop would kick that file back and say, where's this? Because we're not in compliance. So I'm mind boggled over how it got to this point. The only thing I can think of as to why it got to this point is that agency disclosure was missing from transactions on every single person that was included in the claim as the respondent, I guess it's called when you're on the other side. And all of the people participating in that class action lawsuit, did they not have an understanding who real estate agents represent in the file? Did they not have an understand or, the exclusive buyer representation agreement? In that exclusive buyer representation agreement, if the client or customer refused to sign that exclusive buyer representation agreement, then they needed to know through the understanding who real estate agents represent that the agent, left side of them at the closing table, would be representing the seller. So if they were doing things the way they were supposed to be doing them from the start, and I used to teach agency at the local board, if they were doing things the way they were supposed to do them from the start, the lawsuit would have never happened. If it would have happened, then we would still be looking at the original case of sub-agency for the seller being 0 or 3%, and the agent not knowing who they represent at closing, which is the problem. Then we move forward to inflated sales prices. All right. So part of the lawsuit was talking about inflated sales prices. Well, look, guys, let's fast forward and let's pretend we are doing everything the way we were before sub-agency even started, or before sub-agency 0 became a thing. And we're doing everything the way we were, the way NAR originally set it up, which is understanding who real estate agents represent, buyer agency agreement, listing agreement. Okay. Back then, the whole National Association of Realtors and all of the MLS was set up before before all the sub-agency problems came about the right way, because now it's really going back to the way it used to be. And so let's just pretend that we are in 2002. Okay. Or next year or 2 years from now, the rules are going to be the same. So because the NAR lawsuit made things go all the way back to the beginning. Like, okay, so now let's pretend we are at the closing table and the sub-agency for the seller is 0. The buyer signed a buyer agency agreement. And the buyer agency agreement says 3% if there's no compensation in the MLS for buyer agency, or you'll pay the difference of whatever, right? So you'll pay the difference. If the buyer agency commission percent in the MLS said 0, then, and your exclusive buyer representation agreement signed by the buyer, making you the buyer's agent, said 0, you just worked for free. There's nothing you could do about it. So a broker would need to train the agent, please read your documents read all your board documents, read them all, whether you're using them or not, read them. So the buyer agency agreement would have said, if the listing is not paying my broker anything, you agree to pay X% to my broker, which is what just happened. So now I'm like, what in the world? I feel like I'm in like La La Land because none of it makes sense. So you can see all of the YouTube videos, all of the Facebook posts, Instagram posts, all these agents and fear factor people trying to instill fear in everybody about the NAR lawsuit. I'm here to tell you, it's always been this way. What stopped it from being this way is sub-agency for the seller and the agent not knowing who they represent at closing. So let's go back to the example, either before or after, not current, right? We're at the closing table, and now we're like, okay, so seller says, well, I only agreed to pay 3% to the listing broker. Now, hopefully it doesn't get this far before anybody realizes it, but I'm going to tell you, mortgage brokers need to see a copy of the exclusive buyer representation agreement and or the understanding who real estate agents represent now. It's going to come right down the line on an underwriting condition on every single product except for cash, okay? And here's why, or FSBOs. And here's why. Because now the mortgage lender is going to want to know who's paying the real estate commission. Now that everybody's brought it to the attention, to everybody's attention, it's going to be looked for, right? So now the exclusive buyer representation agreement is going to be, I'm just, crystal ball, foreseeing the future. It's going to be required as an underwriting thing as part of the contract. And so is the understanding who real estate agents represent. That's coming back because in the past 7.5 years, they stopped making the understanding who real estate represents a requirement. So the buyer agency agreement is going to have to be looked at because now we need to make sure that the mortgage financing is not including a real estate commission, especially if it's a veteran buyer, okay? Because now that's not even allowed on a VA loan, but we don't want to inflate the price with the real estate commission because the seller didn't want to pay it or the buyer didn't have the money. We're in a bind here. And it's all because of the consumer lawsuit. Like, they hurt themselves, in my personal and professional opinion. That NAR lawsuit hurt the consumer. Share this video. I don't really care. It hurt the consumer because fast forward, nobody wants to be held liable. And now we're looking at the potential for mortgage fraud if it's not disclosed that the commission was included in the price. I mean, that's the realistic outcome is from a national lawsuit like that with all of the publicity that it's received. So the problem with that is going to be that we're all going to revert back to the way it used to be, but only now the listing agent during their listing presentation is going to have to circumvent whether or not the seller is willing to pay the buyer's agent commission. And here comes sub-agency right back into play. That conversation also needs to come up because the seller might say, I'll pay the commission for the other side, maybe of 1.5%, but they're going to represent me if I'm paying it. They're not going to represent the buyer, which is another key point of the lawsuit, right? So they've created and they've opened Pandora's box. But to circumvent that, there's a couple of things that we can do. Now, I'm going to share my screen and I'm going to go back to the olden days, and I'm going to share my original listing presentation. Now, I'm going to do this a two-pager side by side because I want to make sure that we get through this fast. If I'm sitting at the seller's house at the table, I'll be there an hour explaining this, okay? So if you want specific training on how the dialogue on this presentation and how to get the listing, I'll be glad to help you with that. But there's a couple of things in this presentation that have changed that, the dialogue on getting the listing isn't the part of this webinar or Zoom. So I'm going to skip that. Okay. But these are some of the frequently asked questions. That's a personal guarantee. But this page right here, this merchandising review, okay? I just want to talk about this briefly. So this paragraph right here, I'm going to highlight it and try not to, this one right here. If your home, I've got a pointer, let me get a pointer, annotate right here. If your home is competing with the home down the street and that home is paying 3% or 4% commission versus your listing at 2.5%, which home do you believe the buyer's agent will make 100% effort to sell? It didn't say anything about which ones do you think will get shown. It says, which ones do you think the buyer agent or sub agent, doesn't really matter, will be standing in the kitchen talking about the smelling of the Thanksgiving turkey and bringing out all the senses, all of the sales psychology things, you know, helping the buyer visualize their furniture in the house, their birthday party out back, the pool party next spring, you know, helping, using what they're supposed to do and sell the property. You know, if there's any issues, bring it to their attention. But if they really want to sell that property, they're going to bring out the 5 senses in the customer or client. Okay. And they're going to, you know, go on and on and on about it. So the next one I want to tell you about is this one. In the same respect, if you're offering a 3.5% commission or a 4% commission, buyer's agent or sub agent, doesn't really matter. Most of your competing listings that are offering 3%, that's, which one do you think will sell first? It's creating a competitive advantage for the seller. So why are the sellers filing a suit over it? You know, like, it blows my mind. It's uneducated consumers. And you can tell I'm passionate about this. So I just wanted to bring that to those two things to your attention. And let me X out the annotation. So this is where I have the 3 options. And now I need to get rid of this thing. I don't even know how to get rid of the annotation now. If the, hold on, let me see if I can get rid of the annotation. Can I erase it? I don't even know how to get rid of it. Trash, clear all drawings. Okay. So if we are at the table, and this, again, I've been using this forever and ever and ever and ever and ever since the beginning of my career. I've always given the seller 3 options. 3 options. One of the overcoming objections dialogue, when they would interrupt my, you know, let's schedule an appointment for Tuesday at 7 o'clock. When they'd interrupt that and say, what's your commission? Always, hands down, always something you get caught off guard with. Well, I don't even set the commission. You do. And at the end of my presentation on Tuesday at 7, you will know exactly how much commission you'll want to pay. Fair enough? Dialogue. Okay, yeah, that's perfect for me. It's marketing and sales psychology. Ball in their court. They can't have seller remorse on the price, on the commission. And they can't claim that all real estate brokers were price fixing, which circumvents the biggest portion of the NAR settlements. They should not be paying those settlements, and they should have not lost the lawsuit. Because I'm here to prove to you, I think I revised this last in 2019, right there. But I've been an agent since 2001. And I printed hundreds and hundreds and hundreds of these spiral bound listing presentations and left them with the seller and taught them to hundreds and hundreds and hundreds of agents, sold it on Fiverr. If they could prove that even a handful of agents had a listing presentation that gave the seller 3 options, then that's reasonable doubt on whether or not any broker was price fixing anywhere in the country. Am I right? I never price fixed. The seller told me what they were willing to pay for my service. Now, I think the lawsuit quoted it as price grouping or clumping or something, which is the same as price fixing under the law. Okay. Now, if that's what they were doing, I want everybody to stop what you're doing right now, go on to Google and search pepperoni pizza near me, or search Starbucks coffee. Okay. If the prices are anywhere near the same, $7.15 for a grande, iced chai latte, with almond milk. If the price is the same, then they're doing it too. Why is it okay for one industry and not okay for another? It's strange. So they're not saying all Starbucks franchises are required to charge $7.12 for their grande iced chai latte with almond milk and cold foam, right? Or ABC Pizzeria must charge $20 for a large pepperoni, right? Nobody said that. Just like it is in the NAR, it's in their ethics, it's in their rules, it's in the real estate state and national licensing rules, the laws, that there's no price fixing. So this is not price fixing. I'm telling you, my services, if you want me to do all of these things that I have to pay for separately, I have to pay for lock boxes, I have to pay for the MLS database I have to pay for professional photos, I have to pay to advertise on social media, I have to pay for the dot loop and the DocuSign and the MLS subscription and national referral memberships. I have to pay for the showing services and showing time and brochure boxes in the color brochures. Me, the agent, has to pay for those things. So why is it okay, or why is it not okay for me to do all of that? And if I have a transaction coordinator and a real estate assistant and a receptionist, or, I have my own branch, if it's okay for me to have all of the expenses underneath the gross revenue of 6% of your sales price, and I can call my profit this little tiny, whatever it is left over after paying my assistant, the transaction coordinator, and all of these fees. All of the broker does not pay that. The agent does. And it comes out of the agent's portion of the broker agent compensation. So if I am at Century 21 and I'm a Centurion agent, I get paid 75%, they get 25%. So if I take a 6% listing and I'm cooperating with a buyer agent, 3%, or whatever I want to cooperate with, 2.5%, whatever it is. My 3% is then collected by the broker, the pimp, and then they pay me based on my percentage split. And then all of these expenses that's highlighted on this screen comes out of my portion, not theirs. I'm not sure if people, and I actually remember getting into an argument with somebody about this at a bar in Southern Maryland, where they had no idea. This is a pretty intelligent guy. They had no idea that the agent's expenses come out of their share, and all of the expenses, it's a business. And so the gross revenue would not be 6%. It would be 75% of 3%. And then all my expenses come out of that. And then what's left over is my profit. So this is the package, the basic listing package for 6%. Scrolling down, I'm going to give them the premier package for everything in 6, or everything in the basic. Plus, look what else I'm doing. I'm going to cooperate with the buyer's agent or the other agent, 4%, giving the seller a competitive advantage for them. I'm going to do an email blast through my my MailChimp, my CRM, whatever. I'm going to put your listing on my website as a feature listing. I'm going to make sure all of these backlinks are in, all of the syndicated listings include all of these ways to share. So I'm going to post your 1234anywhereplace.com to realtor.com to Homes Database, Google, Yahoo, LinkedIn, Facebook, Twitter, Instagram. And I'm going to also throw in $150 in Facebook targeted advertisements. Now, why am I going to do that? Because if they are cooperating 4% to sub-agent or buyer agency, and I'm going to get 3, I'm still getting in my mind the typical or my justified 3% gross revenue before my split with my broker for the services that I provide. And because I have, the ability to win a lot of listings with this presentation, I'm also in the position to be able to afford, because I have more gross profit, be able to afford to do some extra stuff for you, like the 400-piece just listed postcards, full color, whatever. But here's the requirement. This is a negotiable transaction. I am negotiating with my potential client at their kitchen table, and my number one objective is to get the listing and make sure that the seller understands what they're getting if they hire me. So I'm not going to go through all this without a minimum of a 12-month minimum listing period. Now, it's negotiable. So if you think that in one of the dialogues in the front, that we can talk about it later in a different Zoom, join me on Seanna's marketing camp and request that training, okay? But one of the things that we would talk about in the very beginning of the presentation at the table is, that one of the frequently asked questions is, I have a bigger marketing budget because I sell more listings because of the competitive advantage that I give by taking a 7% listing. The agents are scurrying around trying to look for my listing. They can literally search listings, Seanna Smallwood listings, active, right? And all of the 4% will be shown up. All of the 2.5s, all of the 3s, all of the 3.5s, and all the 4s will all show up under Seanna if I have listings with that comp. Now, I don't list anymore, but I'm saying past tense. Okay. So you can see from the seller's perspective that they would want to both of them are a really good deal, but I'm telling them that I'm not going to take their listing if neither one of these is okay with them. They can choose not to list with me at all. And if they want to negotiate, I'm not willing to do a 12-month listing, but I will do the 7%. Fine. I asked you in the very beginning of the presentation, what would you, at the end of the transaction, what could I specifically do to make you give me a 5-star review? And they answer the question. And it says, you can sell my listing my property in 90 days. So I can, get to Arizona or Nebraska, wherever they're going, right? Florida. And so we set the expectations up front. So now everybody is under the same agreement that the seller's expectations and, they give you raving reviews if you sold their property within 90 days. So that at that respect, you're compromising and negotiating. Okay, no problem. Well, I'll change this 12 months to 6 months, which now the seller's getting half the listing period. If they're not satisfied, we're probably going to release them anyway. Nobody wants to hold a seller, accountable to a listing agreement. Now in Florida, it's different. The listing broker has the right to, automatic right to put a lien on the property for the real estate commission until it's 1,000% full unconditional release. In Maryland, I don't think it's like that. And it hasn't come down that path yet. But you can see from just what I've shared with you here that the NAR lawsuit is absolutely just, I don't know who their lawyers were, but I'm not a lawyer. I'm just telling you from hands-on 35 years experience that this lawsuit is it's detrimental to the consumers, because now we have a brought to the light issue where the buyer doesn't know if they're going to have to pay for, you know, that whole extra expense. We're talking about first-time home buyers that don't even have their down payment, that would have qualified pre-lawsuit, and now they don't, right? We're talking about first-time home buyer, move-up buyers. The seller on a move-up buyer, they're having equity, right? So let's just say they net $50,000 from the sale of their house on 1, 2, 3, 4 Anywhere Place, guys. That $50,000 is going to be used as a down payment, plus pay their own closing costs on their purchase. I'm going to let that sink in for a minute. Who is paying the real estate commission on the purchase if it's not the seller on the first house with their equity? The only thing this lawsuit did was create a situation where sellers are going to sit on the market for longer than those negotiated 6 months, because buyers now have to, going back to the exclusive buyer representation agreement, where that, you know, that conversation needs to be really talked about now, because now it's a thing. Well, it was always a thing, but it wasn't a thing because at the, you know, pre-NAR lawsuit, the sellers were like, I'm going to pay it anyway. I'm going to pay it in this expense on this transaction, or I'm going to pay it through my net on my next transaction. Either way, the seller's net proceeds is money they never had without a buyer. Facts. So now the claimants or the participants in the class action suit are creating or have created a situation where we were reverting back prior to sub-agency being 0 because of that problem. Okay, we're reverting back to the beginning where the buyer's agency agreement places fear into the buyer. Well, I'm going to tell you from hands-on experience and working in the real estate community for 30 years, I'm going to tell you, as many conversations that I've had with other agents, with as many conversations that I've had with friends, peers, social media friends, comments, posts, everything. Everybody, if you go on my Facebook, you'll see I have like 5,000 max friends, plus like 3,000 followers, Instagram, LinkedIn, all of them. There's crazy amount of followers on social media for me. Not like, you know, famous, but crazy. So the biggest consensus and widespread belief is that the buyer's agent commission is paid by the seller in the first transaction, but technically through their net, they're paying it again in the next transaction because the seller in that transaction was cooperating 3% to the buyer's agent, and that broker, the listing broker, was cooperating 3% to the buyer's agent. And now the seller is, you know, the buyer is paying it again at the time of listing, because when the seller says, I need to net $50,000 on my next purchase, they have to build it in or the seller's not going to list. So big question, are we shutting down real estate and like doing things different? Or are we just going to revert back to the original where we have an exclusive buyer representation agreement where the consensus upon all of the United States of America and everybody talking about buyer agency, the number one thing that people say they're not going to do is sign that document. Okay. So now the buyer agent or the buyer, because of horror stories of the buyer's broker not letting them out of the agreement, is refusing to sign an exclusive buyer agency agreement. Okay. And so they're gonna do what? They're gonna be a sub-agent for the seller where the comp is 0. Well, I don't work for free. You want me to provide all of my services, show you properties, send you properties with my MLS access, my subscription I pay $200 quarterly for, or $800 a year for the membership of the board, plus more than that on some associations cross country. You want me to pay all of my marketing expenses for all of the sellers that I did sell properties for, who did agree to follow my advice, and their properties were successfully sold and on time. You want me to take my gross or net profit, not gross revenue, net profit after my broker gets a share, and you want me to take my little tiny bit of money and pay for the gas, pay for the car insurance, which insurance is extra when you're a buyer's agent and you have people in your car. You want me to pay all of these extra fees, lockbox access. I had a key card, guys, that I pay for that will allow me to enter the lockbox. I pay for that, not my broker. Enter the lockbox, put my own little code in there, register Seanna Smallwood was in that property on such and such day at such and such time. I was able to schedule the showing through showing time, which I pay for the membership. I was able to write the contract through Loop, which I pay for the membership. I'm going to spend my 2 hours to write the offer the way you want to and get you pre-approved with the lenders that I can recommend you. And I'm going to do all of this work, but you don't want to pay me? So it's not fair and it's incorrect. The whole lawsuit is incorrect. It should be completely reversed. It should not have even came about. So that's what's different today is what became different over the other lawsuits. So you can't have it both ways. Are we going to reverse the results of those lawsuits? Because people got paid money, damages for those sub-agency claims across the country. Okay. So, or are we going to file a class action lawsuit as NAR to those lawsuits and have the Supreme Court or some appellate court reverse those claims and send all the money back? Or are we just going to say, okay, let's call it, truce. We need to go back to the original way we were doing it, where the understanding who real estate agents represent is a required document. The buyer agency agreement is required if the buyer selects represent me. It is not required if the buyer selects sub-agent for the seller. It is not required if the buyer doesn't want a buyer agent at all and doesn't want to be shown properties. They can just go knock on FSBOs or call listing agents, right? That's the only options. So what I want to do is I'm going to close this Zoom. I'm going to post it to YouTube and I'm going to share the link everywhere. But what I would like you to do, guys, is copy this link. Let me see if I can I'm going to copy it. And I'm going to throw it in the chat right here. That is a form that will allow realtors to submit their name, their email address, their phone number, their broker logo, their profile picture, their bio, all of the information that they would need to have an automatic, systematic, auto-generated flyers created through MyProGenie under the whole shebang bundle. When you click that link and you open it up, you're going to see like a big intro paragraph. And on that paragraph will be a link to join the Facebook community for Mavericks, which is Realtors, and a link to join the Facebook community for Seanna's marketing camp. And originally the camp was just set up for Edge loan officers, but I'm opening it up to Realtors and other loan officers. Because MyProGenie is a beta project that I'm working on, and I need loan officers and realtors as the beta testers. So, and the MyProGenie product is, I can't talk too much about it because it's a huge surprise, but the product itself will have the templates. There's 35 templates, marketing templates, just listed, just sold, check out the YouTube channel. All of this like demos of templates and use cases and stuff are on there. Just follow it, go through the thing. And I do the training every Tuesday and Thursday at 12 noon Eastern time. And we can even address or go over the listing presentation that we just discussed in one of those times. So meet me over there in that community. The Google form will create a list of a Google sheet of all the agents in our community, all the loan officers in our community, and I will be able to automatically generate co-branded or individually branded flyers from all of the templates in the bundle, the whole shebang bundle. Okay. And I'm super excited about it. And from there, because you bought the bundle, if you buy the bundle, I'm going to use all of the people that have bought the bundle as beta testers for my Pro Genie. And it's going to blow your mind what this is going to do. So I can't wait. I'm super excited. Thank you for being here. If you have any questions, drop comments below, like my YouTube channel, follow me, do all that good stuff, and share this video with NAR leaders. Share this video in your realtor groups, in your referral groups, because I can tell you this video will be hopefully the muscle that they need for going back at them for filing any kind of appeal or countersuits, because the whole thing, the way I just presented it to you should make complete sense if this video alone was showed to a jury, right? Or to a panel of their peers, or to anyone that had any, say in that judgment against NAR. It's absolutely bonkers. We're not price fixing. We're not charging the seller. We're not charging the buyer, putting it to the sales price. What we're doing is making the client happy by making sure that they have enough net to move forward with their purchase, where they're going. This is other people's money. It always has been historically, because over the last 100 years, every year on average, the value of real estate increases, which is why United States of America, we're not talking about economics anywhere else, which is why the real estate industry makes the freaking economy go around. It literally is the #1 industry that affects the gross domestic product. So what are you doing? What are you doing? My name is Seanna Smallwood. I'm an expert real estate and mortgage broker. I work for Edge Home Finance. We're a national broker. We're #1 with the #1 wholesale lender in the country. We have hundreds and hundreds of products. I would love to talk to you more about my business, but this is for you, realtors. Please share. Talk to you later. Bye.